morning, everyone. Welcome you to ITIF event on economic doctrines and antitrust policy. And I'm Rob Atkinson, President of ITIF, and I want to first of all say that growing up in Chicago, I can only remember having the schools closed twice. One was 24 inches of snow, the other was 36 inches of snow. The fact that Washington shut down for days on end for 5 inches is beyond what I believe, but in any case. So I'm glad that you all braved the weather to come out here today. Speaking of weather, my colleague David Adresh has had 2 planes canceled yesterday to try in his efforts to get here. David's either coming from Indiana or Germany, I can't remember which. He's in both places, and he sends his regrets that he can't join us, but he is the co-author of the report we're releasing today. So what I want to do is just start quickly by introducing our 3 distinguished panelists. I'll then present what we think are the principal findings of the report for about 20 minutes, and then we'll turn it over for comments from each of the panelists for about 10 to 12 minutes each, and then we'll have a dialogue and discussion, and we'll adjourn precisely at 10:30. I'm going to start with, on my immediate right, Seth Bloom, who is General Counsel of the Senate Antitrust Committee on the staff of Senator Hoover Phone. He's responsible there for antitrust, competition, and other business regulations for Senator Cole. He's been on that staff for the past 11 years. He's also principally responsible, has been responsible for several key pieces of antitrust reform legislation sponsored by the Senator, including the Discount Pricing Consumer Protection Act, the Preserve Affordable Access to Generic Drugs Act, the Railroad Antitrust Enforcement Act of 2009, and the No Oil Producing Exporting Cartels Act. Prior to joining the staff, he was a trial attorney at the Antitrust Division at DOJ, and he has a JD from Penn and a BBA from Rochester. To his right is Janet McDavid, who is a partner at Hogan and Lovells, where she also focuses on antitrust and trade regulation litigation. She is particular emphasis on government investigations, litigation, and legislation, and has served as counsel on a wide number of antitrust matters, including Mobil Corporation and its merger with Exxon, Daimler, Chrysler, GM, and Ford on joint ventures, Visa, MasterCard, and a wide array of others. She is the past chair of the section of antitrust law for the ABA. She's now an officer of the International Bar Association Antitrust Committee, a non-governmental advisor to the International Competition Network. She's on the Antitrust Council of the Chamber of Commerce. Has written numerous books and articles on antitrust. She's also served on the transition team for the last 3 presidential administrations on antitrust, and has a wide, obviously, background on this issue. Has a JD from Georgetown and was an editor of the Georgetown Law Journal. And last is Joe Farrell. Joe is, I guess, relatively new on this round back to Washington. He rejoined Washington in April of 2009 when the FTC named Joe to head the Bureau of Economics. Prior to that, he was an economics professor at UC Berkeley, where he chaired also chaired the Competition Policy Center there. He joined Berkeley in '89 as an associate professor, became a full professor in '91. He also previously was Deputy Assistant Attorney General for Economics with the DOJ, and also was Chief Economist with the FCC. He served as an editor of a number of different journals, and he received his PhD at Oxford in 1981. So as you can see, really a highly distinguished audience, and a great audience too. I'm going to read all of your bios now, and we'll adjourn. Highly distinguished panel, sort of in a way feeling somewhat in awe, since I'm not a lawyer, more of an economist than a lawyer, but I think the reason David and I wrote this paper is it builds off a report that he and I wrote about a year and a half ago called Economic Doctrines and Economic Policy, Why Washington Can't Agree on Economics. And that report was an attempt for us to really disentangle the debates in Washington around economic policy and say what's really behind all these debates, what's underneath them. And what we essentially argued in that piece was that there are these distinct and competing economic philosophies or economic worldviews, or what we call economic doctrines. And these doctrines essentially shape these debates. And no matter how rational one might think one is, how objective one might think one is, virtually everybody who is involved in economic policy, whether they're an economist or whether they're a staffer on the Hill or whether they're in the administration, has and subscribes to an economic doctrine. They may not even know what it is, but they have a philosophy and a doctrine. And as part of that, we laid out how these different four doctrines apply to different policy areas, and one was antitrust. And this is an area David has written on, 30 years ago, started writing about this question, and so we decided to explore this issue more in depth. So what do we mean by these economic doctrines? Well, quickly we argue that there's really four competing economic doctrines today. One is what there are two in what are called the neoclassical economics school. Neoclassical economics kind of is the main school of economics. There's a conservative version and there's a liberal version. The conservative version is what you might know of as supply-side economics. But essentially it was the economics doctrine that most of the people in the Bush administration subscribed to, very much oriented to free markets, limited government, etc. There's a liberal version of that, which one might know of as Rubinomics. Somewhat folks in the Obama administration, I would argue, subscribe to this. Larry Summers would be a good example of this. Generally, again, focus on markets getting it right, a focus on what's called allocation efficiency. Markets generally allocate things according to price. You don't want to get in the way of that. And the main difference between the liberal camp and the conservative camp is the liberals would be more oriented to issues around fairness and equity and be more willing to acknowledge that there is some role for government. Third, there's another camp which one might call the Keynesian camp, which is much more liberal, much more about markets generally don't work all the time, but much more about the focus should be really on worker and welfare as opposed to consumer welfare. And then lastly, there's been this emerging doctrine in the last, for perhaps a decade, of what we've called innovation economics, but what a lot of people call, if you're a policy wonk, you would call it endogenous growth theory or new growth economics or neo-Schumpeterian economics. But essentially it's an economics around that puts innovation at the center, and it's said that the other doctrines really largely ignore innovation. They're about static allocation. Innovation economics is, look, innovation is the most important thing in determining economic welfare. Markets don't always get that right. There's a role for governments for innovation. So when you think about antitrust, it turns out that we would argue that there are four doctrines that align very, very closely in antitrust to these economic doctrines. And the reason for that is quite simple, is that at its core, antitrust is largely informed by economics. It's about how economics plays out in the legal realm with regard to competition. So it's not surprising then that we see these different economic doctrines playing out in antitrust. So what are the four doctrines? Essentially, we would argue the four doctrines are the Chicago School, which we'll describe these in a moment, but the analog of the Chicago School would be the supply-side economics, conservative free market orientation. Post-Chicago, which was essentially, again, neoclassical, market-oriented economists, but arguing that there are limitations to the Chicago School. The populist school, which sort of emerged in antitrust after World War II, and is more akin to the Keynesian, more liberal school. And finally, what we would call the innovation school, or another word that some people use is the California school, partly because some of its practitioners, Joe, I don't want to put you on the spot and call you a Californianist, but Joe was from California, Carl Shapiro, other people have written about this. There's sort of this notion that some of these new views come from the California school. So let me just quickly go through this. The populist school is essentially saying that the goal of antitrust is really about not really just about allocation efficiency, but has a whole set of values around things like equity and making sure that there's fairness in the system and making sure that consumers are protected. One quote that the populist antitrust scholars like Lawrence Sullivan, Bob Katofsky, and Robert Landy have argued, quote, that the goals of antitrust should be, and always have been, far broader than the narrow type of allocative efficiency. They encompass ensuring fairness, protecting the technical process, controlling wealth transfers, limiting the accumulation of private economic power, preserving the freedom of individuals and enterprises to engage in economic activity. So this populist view is much broader than kind of this narrow view of just making sure that markets work and allocate things efficiently. And after World War II, this really became known as the Harvard structure conduct performance paradigm. It's very much focused on the structure of industries with the view that you can determine whether markets are competitive simply by their structure. If they have sort of high levels of concentration, this is probably a problem. There's a sort of a shorthand to this, which was big is bad, small is good. So after this was essentially the dominant doctrine through the 50s and 60s, even into the early 70s, and in part because of its limitations, in part because the world started to change, you have this reaction, this sort of antithesis coming out of the Chicago School, which was named for the scholars at the University of Chicago who postulated this new approach. People like Director, Bowman, Judge Bork, Posner, and Stiegler, who essentially said that really antitrust had gone way, way too far. That antitrust really has only one goal, and that goal should be the pursuit of allocation efficiency that improves consumer welfare. If it's something in the marketplace really it doesn't do that, then maybe there's a role for doing something, but absent that, there's really no role for government. As Bork describes it, he says, quote, the whole effort of Chicago was to improve allocative efficiency without impairing productive efficiency so greatly as to produce either no gain or a net loss of consumer welfare. So Chicago was much more willing to engage in trade-offs if a merger or some sort of activity would lead to higher efficiency, even if it might lead to some short-term consumer welfare loss. So, you know, a merger may prices go up a tad, but if overall efficiency in the short run goes up, Chicago is much more willing to say this is probably in the public interest. So you had Chicago, and then after, and I'm really skimming over a lot of this in the interest of time, but essentially out of Chicago you had a reaction which was obviously post-Chicago, and post-Chicago recognizes and accepts much of Chicago, but differs in some way. And as post-Chicago and John Baker, who now, I guess John's now at the SEC, he just joined the SEC a little while ago. John, as stated in a recent article, says, quote, new developments in antitrust economics demonstrate, quote, demonstrate that we need not reject the value of economic efficiency in order to question the Chicago School. Its challenges to Chicago rise within the efficiency paradigm. So post-Chicago really accepts much of what Chicago framed it, but they differ in certain key areas. Those key areas essentially are that Chicagoans generally see market power as the result of firm superior performance. So if market power emerges in a marketplace, it's not usually out of any nefarious action or anti-competitive action by an enterprise. It's really because they're highly efficient. Post-Chicagoans, in contrast, are much more willing to see market power as the result of anti-competitive actions by firms. Secondly, even if there are the emergence of dominant firms in marketplaces, Chicagoans are usually willing to believe that these are self-correcting largely through entry. So if you have a dominant firm emerge, the idea is you have supernormal profits that attracts in competitors, therefore the problem is solved. Post-Chicagoans would see entry barriers as higher in many cases, making it harder for new entrants to emerge, and therefore limit the ability of markets to automatically correct. And third big difference between Chicagoans and post-Chicagoans is Chicagoans generally, even if they think that the market might not get it right, they generally think government action would even be worse, particularly with what they would argue is a failure of the judicial process. The judges aren't trained in economics, they don't understand these things, and therefore they will make bad decisions. Chicagoans are much more, as well as bad decisions within antitrust authorities. Chicagoans are have much more faith in the ability of government to accurately distinguish between competitive and anti-competitive behavior and essentially get it right. So after these these debates were being played out, there was this other school that emerged and that started to gain more and more traction, particularly in the last decade, and that's what we would call the innovation school. The innovation school really differs with the Chicago and post-Chicago and popular schools, really in several main areas. First, the innovation school doctrine places much more emphasis on productive and dynamic efficiency. In other words, we should be evaluating, I say we because I would argue ITIF is the innovation school when it comes to antitrust. But innovation proponents would argue that we should be evaluating actions in the marketplace principally on their impact on productive efficiency, in other words, on productivity, and also on innovation. So essentially, they're saying, we should, if there are losses in allocation efficiency, let's say a merger, it creates some market power, creates some pricing power. Usually, those cases, usually what will happen is that you'll have productivity growth that will vastly outstrip those losses. Mike Porter recently argued at Harvard, who I would put in this camp. Porter argues, quote, productivity growth is much more understandable and palatable to managers. Imagine how much more constructive it would be for corporations and their attorneys to debate whether a merger will boost productivity growth rather than continuing to debate the size of HHI, which is Hirschman index of how much concentration there is in the market. The second, I think, difference is that the innovation school, again, focuses less on competitive markets, as the goal is not competitive markets, and the goal is actually innovative and productive firms, particularly in global marketplaces. And I think that's an important distinction because in a new global economy where U.S. firms are competing against competitors in other industries and in other countries, we don't want an antitrust regime that weakens the strength of U.S. companies to go out there and be successful competitors. And so while, again, there may be some short-term harms that cause, in the long run, if we're boosting competitiveness, that may be worth the trade-off. The second big area, really the principal area, is that I would argue the innovation school principally looks much more at dynamic effects. The other three schools are looking at short-run effects. They're looking at price, how it's going to change the allocation right now. The innovation school would argue that we really need to be looking at dynamic effects over the moderate and long term. For example, Mike Porter argues the effects of mergers on competitive practices on the overall rate of innovation are usually only paid lip service by the other doctrine. They may talk about it, but they don't quite take it seriously. So why would you want to do that? Well, it could be, for example, that a merger might increase market power and might, quote, hurt consumers in the short run. But if it's an industry where that market power and those increased profits are reinvested into research and development and new product development, that merger might be justified because the long-term benefits to society could be significant. I'll quote Carl Shapiro, and I probably shouldn't quote Carl. Maybe I won't ascribe this to his current position at DOJ, but an article that Carl wrote before he joined this current administration, he said, quote, if appropriability is low, in other words, if companies can't gain all of the benefits of their own innovation, for example, due to weak intellectual property rights and significant spillovers to rival firms, then increased concentration can improve appropriability and promote innovation, weakening the link between concentration and competition. In other words, this notion that we really should be looking at these dynamic long-term effects that might benefit the overall economy. And the last difference, I would argue, is that in the innovation school, I think there's much more of a recognition that industries are quite different and that you can't apply a one-size-fits-all approach to all industries. And in particular, that any innovation industries tend to have different dynamics and different characteristics than, say, more commodity-based industries with low fixed costs and high marginal costs. High-tech industries tend to be the opposite. They tend to have low marginal costs, high fixed costs and low marginal costs, which means that their behavior in marketplaces can be quite different. Another component of this difference, I would argue, is that in the conventional economic doctrine views, antitrust views, you tend to think about competition as being in the marketplace. So you would analyze the marketplace between companies that are already in that marketplace and say, here's what the competition is going to look like. In the innovation doctrine, you would essentially look for competition not just from there, but also from new entry. In other words, there is this sort of Schumpeterian notion of creative destruction, that new entrants come on board at any particular time and change the dynamics. The last part of this is related to differences between countries. And I think one of the big, I would argue, limitations of the kind of prevailing doctrines of antitrust, particularly Chicago and post-Chicago, is they tend to assume that everybody is a utility-maximizing rational actor, whether they're in the United States or any other country. In other words, they think everybody's like us. In fact, not everybody is like us. Other countries have very different market dynamics, and we can't evaluate what they do on the same basis. Let me give you, I think the emblematic case of that was the 1986 case, Massachusetts Electric Industrial Corporation versus Zenith Radio Corporation. This was a case where Zenith, remember Zenith, this was actually one of the dominant electronic companies in the world, made TVs. And they alleged, and I would argue correctly, that Japanese firms were colluding to charge high prices on televisions in Japan so they could engage in predatory pricing in the U.S. I just actually got back from Japan yesterday, and I noticed this, that prices in Japan for certain things were a lot higher than here. I talked to my host about this, and they said, oh yeah, we always come to the U.S. to buy things. It's not just a dollar-yen thing. Well, the judge at the time, who was influenced by Chicago and post-Chicago, essentially ruled, no, there's no way that the Japanese would do this because it's irrational. And in sort of the Chicago school, you don't have predatory pricing on a collusive basis because the incentives in the marketplace are for Sony or somebody else or Panasonic to not agree to this and to start charging low prices in Japan to gain market share and put the other guys out of business. So in other words, Chicago and post-Chicago just simply assumed that the market looked like it and worked like it did in the U.S. When in fact, the Japanese market works and looks completely different than our market. Firms do collude. This is what Japan was all about, and they colluded enough. And whether that was the only reason why Zenith went out of business, and Japan won the television market, I'm not going to speculate on. But clearly this was a case where it would have been better to look at antitrust from this lens of that there are different institutional frameworks. And we see that today with regard to different countries around the world, particularly the EU and Asians and Japanese and Koreans and Chinese now having very different approaches to antitrust. So in the limits of time, let me just go through one last area. There's a bunch of it in the report, but let me just go through one last area, which was on essentially, we go through the report, we talk about how these doctrines affect monopoly and market power, collusion and pricing and others. But let me just go through and talk about collusion for a minute. The notion of collusion, which in and of itself really is a sort of negatively charged term, collusion, use the word cooperation, that would be sort of like net neutrality in a way, an emotionally charged term right from the beginning. But the notion there, really built into antitrust thinking, really from the Sherman Act, is really this notion that somehow firms must never ever collude. They must never ever really cooperate, because as Adam Smith said 200 years ago that people in the same trade seldom gather without conspiring to set higher prices. So we should always assume, sort of the populist school always assumes that anything companies might do collaboratively got to be all about price fixing and hurting consumers. Chicago takes a different view about collusion. As Borkus writes, many price fixing and market division arrangements make cooperative productive activity more efficient and should be judged according to circumstance. Now this is largely the Chicago ideology that anything that happens in the marketplace has got to be done for a good reason, otherwise it wouldn't be done. And clearly, on our view, this would be an overstatement. So therefore, Chicago tends to look at these things from what's called the per se rule, whereas the rule of reason, whereas the populace would look at it from the per se rule. Just if you're doing this, it's just flat out wrong. I would argue, though, the innovation school is a little bit more on the Chicago side here, and it says, you know what, there are lots of areas where, quote, collusion could actually be quite good. It could be used to organize, efficiently rationalize production. It could be used to create de facto standards that allow marketplaces to work. And Michael Heller, who's a Columbia law professor, recently wrote a book, a wonderful book. In the book he writes, the widespread suspicion against collusion in conventional antitrust has gone too far, and in some cases we should promote what he says pro-trust instead of antitrust. In other words, there are areas where we want these kinds of collaboration, like patent pools and copyright collectors, to use as an example. So I'll just close by talking just very quickly about how does this all play out internationally. I think one of the biggest challenges we have today is that with multinational firms, we really have these competing international frameworks. I mean, imagine U.S. corporations in the 40s and 50s who wanted to have a merger, and they had to go through New York merger policy, and then Illinois merger review, and California merger review, and the New Yorkers had a completely different view of merger than California. That's really much of where we are today. Multinational firms that are competing across borders, and yet the antitrust regimes they face are quite different. I think this is a big limitation of Chicago and post-Chicago, as I said, because they tend to assume that these countries are all like us. They tend to assume that they are all sort of abide by the allocation efficiency principles of neoclassical economics. In fact, I would argue that's quite wrong. The EU in particular seems to be guided by a mix of somewhat populist and post-Chicago doctrines, and I would argue they tend to apply the populist doctrines of non-European firms and the post-Chicago to their own firms. In other words, they tend to focus much more on producer interests rather than consumer interests. And we saw this with, I would argue, with many of the cases recently that U.S. Antitrust authorities approved, but the Europeans blocked. Honeywell and GE being a good case, Microsoft being another case. Imagine, if you will, for a minute, if Microsoft were headquartered in Paris, and if GE and Honeywell were German and Finnish, as Siemens and Nokia are, by the way, with their partnership. I think we would have seen quite different responses from European antitrust authorities. I think we see the same thing with Korea, and that's why I think in some ways the Chinese anti-monopoly laws now are really, I think, should bring us all great concern, because at the end of the day, I think the Chinese will use anti-monopoly and antitrust laws as a mercantilist protectionist tool. They'll use it, I would predict, much, much worse than the Europeans ever considered, to essentially just say we're going to manipulate these regimes to gain advantage for Chinese firms and against foreign firms. So let me just close by saying, if I had two recommendations, I guess one would be that antitrust authorities, both here in the U.S. and elsewhere, and courts, should really be much more sensitive to the link between the policy stance or the arguments being made and the underlying economic doctrines. This isn't science, as in the case of physics. This is really much more about argumentation and ideology and doctrines. And secondly, I would recommend that antitrust authorities begin to employ economists with an innovation background, innovation economics background, and really recognize and take seriously that innovation is a more important component of these issues than it has been in the past. And I certainly give the Obama administration a lot of credit, hiring people like Joe and Carl and others who really do, I think, understand that innovation is a much more central part of our economy today than it was in the past. So with that, I'm going to turn it over to Seth. Seth, you're free to come up here or do it from there, or either one.
I'll do it from here. That's okay. And thank you very much for that, Rob. I think that was an excellent presentation. I thank you for the invitation to speak for this audience. Thank you all for coming. I guess I'll start by saying, do that. I'll start by saying I'm not an economist, and I feel really cautious when critiquing or reviewing economic studies. I was in the Antitrust division in the 1990s. I remember how we, the lawyers, felt about the economists critiquing our work. So I think I need to be a little bit cautious. But I think what you've done in this paper, and I commend everybody to read the paper. We were given an advanced copy. It's really an excellent synthesis of these four schools, as you've described them, of economic thinking and antitrust. I was struck in reading the paper by two comments. First of all, at the very end of the paper, in what's listed as conclusion, the authors state that, quote, antitrust must rank among the most convoluted and least transparent of the economic policy instruments. I don't think there's too much doubt about that. And then at the beginning of the paper, you write that antitrust policy, like economic policy, needs an evolving doctrine that matches the economic realities of the time, which is a lot about what you spoke about, Rob. And I think that's very true. I mean, I think it's interesting that antitrust, we hear this debate in constitutional law about the living Constitution. So does the Constitution mean what the framers wrote and what they intended? You know, we have words in the Constitution like freedom of the press. Well, what about television, radio, and the internet? I don't think anybody, including Justice Scalia or Justice Thomas, would deny that that means that television, radio, and the internet is protected speech and shouldn't be overly regulated at the content. So in a way, I think everybody really believes in a living Constitution, even if they're not willing to admit it. But you didn't ask me here to talk about constitutional law, but I just thought that it's an interesting frame from which to look at antitrust, because I think what we have here is really, antitrust is a living doctrine. It's, first of all, similar to the Constitution, written in broad generalities. Section 1 of the Sherman Act forbids contracts, combinations, and conspiracies in restraint of trade. Section 7 of the Clayton Act, as we all know, forbids mergers or acquisitions whose effect may be substantially to lessen competition. I mean, what do these things mean? Each of these economic theories, I think, are equally valid constructions of this very vague and general and flexible language, and I think it all responds to the economic conditions of the time and the prevailing economic philosophy. So I really very much agree with that point stated in the paper. But I think there is one thing that probably everybody can agree on, and that is the importance of innovation. I think in today's world, we all recognize that. I can't imagine anybody disagreeing with the principle that, you know, encouraging innovation is a principal driver of economic growth and of competition. The Justice Department, in its recently released horizontal merger guidelines of last summer, recognized that in section 6.4, and so I think that can sort of be a touchstone to thinking about how we're going to interpret these sort of general provisions of antitrust law. And then as we think about high technology companies, with particular industries in particular, I'm sort of illuminated by a book I recently read, which I'm sure many of you have read or heard of. It's Professor Wu's book, The Master Switch, which I think is an excellent treatment of these innovation issues in information and communications technologies. And so I'm sure many of you are familiar with the book. For those of you who aren't, he follows the business development in information technology over the last 150 years and shows how important innovation was to break the stranglehold of the market that each prior technology or the monopoly or oligopoly that controlled the prior technology had maintained. And these things didn't happen without a struggle, of course, but in the end, it was always successful. So Wu talks about the invention of the telephone and its exploitation by a company which eventually grew into AT&T and upset the Western Union telegraph monopoly, which was the monopoly that existed at the time.
Then how radio came along and threatened the phone monopoly, and then the movie industry, and then television, and cable TV, and ultimately the most disruptive technology of all we have today, which is the internet. I think these examples are very powerful, and as one looks at how economic thinking has informed antitrust law, and I think a recent example that's also very powerful is the Justice Department's, not so recent, but in the last 25 years, the Justice Department's breakup of AT&T. AT&T was the ultimate monopoly. It controlled local, long-distance lines and all the equipment. And as Wu talks about in his book, you couldn't even connect an answering machine to the phone system. There was a device that Wu talks about, which was called the Hoover Phone, which was simply a plastic device that was going to be attached to a phone to muffle the sound of the calls you were making so you wouldn't disturb people around you. AT&T forbid customers from attaching this device, litigated in court against the company that made the device, and eventually destroyed it. I think that's the ultimate expression of the anti-innovation philosophy in antitrust. I don't know which four schools that would fit in, but fortunately that didn't prevail, and we all know the explosion of technology that resulted in the 80s after the consent decree that broke up AT&T. So we have the answering machine, the fax machine, the cell phone, and then the internet itself. And I think that's I think the best example of one of the best examples of how antitrust policy can unleash innovative technology and create enormous multi-billion-dollar industries. So what does this mean for us today? I think it's vitally important, whatever school you follow, that one utilize antitrust law to encourage innovation. And so I'll just tell you a little bit about a project, if you want to call it that, or work we've done on the antitrust subcommittee. We looked carefully at the Comcast-NBC merger, and one of the things we're concerned about is sort of get around what has been a stranglehold held by the cable industry over paid television. And consumers have suffered for the last 15 years with price increases that have tripled the rate of inflation. One new disruptive, innovative technology in this area is the internet, which promises to deliver video to consumers' homes, allowing consumers to get around bundles of programming and allowing them to get around the dominance held by the cable or satellite companies. But the merger has a risk, I think, of suppressing that development. When Comcast acquires all of NBC's content, will restrict that content off the internet. As a cable distributor, will make deals with other programmers, which are conditioned on those programmers not putting content on the internet. I think if that were to prevail, that would really be a loss for innovation in this area. The innovation being internet delivery of video. And so we called for, when we reviewed the merger, were conditions that would stop the merged entity from doing this. And we were pleased that the Justice Department and the FCC came up with conditions to this effect. They have conditions that required Comcast to share its programming on the internet in the same manner which it was required under law to share with competing cable companies, and conditions that prevented Comcast from retaliating against programmers who wish to distribute their television programming on the internet. I think it's an example how antitrust policy can be enforced to encourage innovation, and I think enlightened antitrust policy should do that. So I just brought up the examples of AT&T in the past and the recent Comcast decision to talk about how these debates, I think, are very much alive. But I think whether antitrust enforcers adhere to the Chicago school or the post-Chicago school or the populist school, I think everybody ought to keep in mind of the really central role that this antitrust enterprise can have in fostering innovation and the importance of doing that. And I thank you for writing the paper.
Great. Thank you, Seth. And Jen?
Thanks very much. Like Rob, I'm from the Midwest, and the problem isn't me, it's the other drivers in Washington, in my experience. There certainly are different doctrines in economic theory that apply to antitrust. I'm not certain that the lines are quite as starkly drawn as Rob and David have hypothesized in their very interesting and quite useful paper. Those different doctrines inform different kinds of enforcement philosophies, and let me give you a few examples of recent administrations. In the last couple of years of the Reagan administration at the Antitrust Division, We saw very little enforcement, particularly against mergers, none against vertical restraints, but a lot against hardcore cartels. The Bush administration believed that entry would solve lots of problems and approved the World Pedal Maytag transaction because of the prospect of entry from Korean firms who could make washers and dryers that would be attractive to American consumers. It settled the Microsoft case. The Microsoft case, by the way, was also brought by the Justice Department. It was a universal antitrust case, so not necessarily discrimination against American firms by Europeans. But the Bush administration settled the Microsoft case on terms that many of us thought were inadequate and were less robust than the provisions of the European settlement. And then it issued the Section 2 report, which lasted about 3 months before it was withdrawn, on the theory that it was much too hard to distinguish between the pro-competitive conduct by a dominant firm and anti-competitive conduct. The Clinton administration had a slightly more populist approach to all of this. We think back, for example, on the FTC's remedies in the AOL Time Warner case, which were driven in part by concern that AOL would control too much content. Well, look what's happened to AOL. The same kinds of concerns that are now motivating the UK's review of News Corp's proposed control over B-Sky B, which is being done under a particular UK statute. Even those of us, however, who are more enforcement-oriented Democrats recognize that there were some important advances as a result of the Chicago school thinking. My colleague Tom Leary, who's a former Federal Trade Commissioner, talks about trying to talk to the agencies about mergers back in the 1970s and saying, don't worry, it won't be efficient. Because efficiency was actually viewed with suspicion at the time. So the populist thinking of the 60s and 70s was really kind of amorphous and very hard to know how the lines would be drawn. There is a great deal to be said, as both Seth and Rob have explained, for the importance of innovation to our economy and to competitiveness on a general basis. And innovation is an important touchstone in antitrust thinking. Not all antitrust issues, however, involve questions of innovation. There are hardcore cartels, to be distinguished from competitor collaboration, in which people simply agree to raise prices or to divide up markets. We have some vivid examples in the videotapes that the Justice Department provided of the Archer-Daniels-Midland cartel, where they actually got a whiteboard and said, okay, here's the total world production for next year, and you get this much, and we get that much. When innovation is relevant to a merger, a joint venture, some sort of competitive collaboration, my experience is that the agencies take that issue into account. And perhaps the difference here is between people who view this from the trenches, like me, because I represent companies undergoing evaluation of mergers, joint ventures, collaborations, or even cartels, and people who look at it in a more theoretical context. And for that reason, I think that there is perhaps less difference between particularly the post-Chicago theories and the innovation theories than David and Rob have hypothesized. In my experience, in real deals, in real investigations, innovation is always considered in circumstances when it's relevant. Short-term price effects are certainly part of the analysis, but I've had mergers going back for the last 25 years in which innovation, or whether a merger would spur or retard innovation, has been relevant to the analysis that we presented to the agencies and that the agencies undertook on their own. Michael Porter's 5 forces, in my experience, have often led to very similar outcomes that one would find under the merger guidelines, and particularly under the new merger guidelines, of which Joe should be very proud. The threat of entry is certainly relevant. The threat of substitution is relevant. Bargaining power is now explicitly recognized in the new merger guidelines. Rivalry among competitors and bargaining power of suppliers are all factors that are considered sometimes under slightly different nomenclature. And antitrust analysis tries to be dynamic. It is necessarily predictive, and much of what we can learn may be based on real-world experiments that took place based in the past, such as a company's plant burned down. What happened to competition in the aftermath of that? And what does that tell us about what happens if we were to take a plant out as a consequence of the current merger? Rob's paper quotes Michael Porter as saying that each of these industries is different, and we need to take that into account. In my experience in real-world investigations, antitrust is intensely fact-specific, and every industry is different, and the agencies take that into account. Even the populists have been receptive to arguments about the importance of innovation. Bob Pitofsky, for example, whom Rob identifies as one of the folks focused on populist theory, was the chairman of the Federal Trade Commission at the time that the FTC allowed a joint venture between Ford, General Motors, and Chrysler to go forward to try to use the internet to develop new products and new cars. And it was investigated, but ultimately, the fact that those companies found it necessary to collaborate in order to do this was critical to the FTC's decision to approve the transaction. The Justice Department and the Federal Trade Commission put out guidelines on competitor collaboration in 2000. The European Commission, earlier this year, published new guidelines on horizontal agreements among competitors. And there's a great deal of overlap, I think, between those two guidelines. They use a method of analysis in both cases that is very similar. They recognize the importance of identifying the pro-competitive rationale and consequences of collaboration among competitors, and that's relevant to the analysis in both cases. The new U.S. merger guidelines and the European guidelines take into account non-price effects of mergers. The U.S. guidelines doing so very explicitly in the section that Seth cited. And the U.S. guidelines and the European guidelines with respect to mergers both take into account the desirability of efficiencies and pro-competitive rationales. One thing I think is important to distinguish is collusion is a term that we apply to hardcore cartels, only to hardcore cartels. We talk about collaboration between competitors being something that has potentially pro-competitive consequences, and therefore we look at the pro-competitive effects, including innovation. Hardcore cartels bring very little to the table other than price increases for consumers and probably retard innovation. I do strongly endorse the point that you make at the very end, Rob, which is that the agency should include a broad range of different disciplines within their economic stance, and I think they do. Because different ways of looking at things in different perspectives will bring the best possible approach to these kinds of issues. And in my experience, that's what Joe and his team do, and that's what Carl and his team do.
Great, thank you. Joe, did you have slides also?
Yes.
Dave's next mission.
Dave?
Yeah. Good. Okay. Let me start anyway. Here we go. So, thank you for inviting me, and I have a lot of comments. I will try to squeeze them into the 8 to 10 minutes that I was asked for earlier, or at least into the 10 to 12 minutes that Rob mentioned this morning. Let me start by pointing out that, as many of you will be familiar with, I'm not here to represent the Commission. The views I express are my views and should not be attributed to others. I found the report, and as I think Seth mentioned, we got advance copies So what I'm going to say is based on the advanced copy. Could have changed. I found the report to be helpfully provocative framing of some important questions. I think it's great that there's an outfit raising these issues, putting forward a point of view, and describing some of the arguments. I do have to say, it struck me that there were some straw men in the report. Some of the positions attributed to the various schools, I frankly didn't recognize from any kind of modern antitrust enforcement. It's, of course, often a helpful technique for provocative discussion to oversimplify some positions, but I wanted to clarify that I think some of that is going on, and that shouldn't retard your enjoyment of reading the report, just something to keep in mind. Different perspectives in the economics of antitrust. Yes, we try to have that internally, and as a safety valve on that, we are very open, and I think all the practitioners here would confirm this. We are very open to listening to different points of view, responsibly expressed by knowledgeable and thoughtful people working for the parties in a merger review or any investigation. We take those things seriously. We evaluate them. We are willing to go back and forth repeatedly. And so if there's some line of thought that we are not paying enough attention to, bring it to our attention. That's really the best resolution there. So it seems to me there are a couple of points to make. One is a substantive point which echoes some of what Seth and Janet both said, and that is that in practice, innovation has been and continues to be key in the antitrust agency's thinking already. So if ITIF, if Rob are pushing for innovation to be on the agenda in antitrust review, that's pushing on an open door. Of course, you could still push for it to be more important, and I think that's the right way to interpret what they're saying. But nobody should think that antitrust review currently has a purely short-term focus, doesn't think about innovation, doesn't care about innovation, or anything like that. It's just not true. Seth mentioned the AT&T case, where there was some squelching of largely complementary innovation. It took the Telecom Act to even try seriously in modern times to bring competition against the AT&T core bottleneck, or the Bell core bottleneck, as it was for an interim period. Microsoft, again, similarly, was directly about squelching complementary innovation in a longer-term sense. That was very much the focus of the Justice Department's case about squelching competing innovation. That is, the concern was that the widely adopted complement, the browser, could have facilitated the entry of something that could substitute for or bypass the Microsoft operating system. If we turn to more direct substitution innovation, let me comment briefly on the Intel settlement. And let me stress two things. I'm not speaking here for the Commission. If you want to know what the Commission thinks, there are documents on the website. And I would also stress that this was a settlement. Intel did not admit to any of the conduct prohibited in the settlement, and we should recognize that. However, from my point of view, the Intel investigation and settlement were about the following concern: that some of the time, and for some purposes and some users, rivals, notably AMD, had come up with superior products. And Intel responded in a variety of ways, allegedly, including, but by no means limited to, trying to make better offers itself. And the case, the investigation, the settlement were really about trying to prohibit the alleged conduct that, if in fact engaged in, would discourage the adoption of these superior products by means other than making a better offer by Intel. Okay? So that is a fundamentally pro-innovation position. One thing that's important about it is it makes the point that incentives for innovation are not just something for incumbents. It's also very important that potential entrants have full incentives for innovation. If they come up with a better product, that better product should be widely adopted, and that process should be profitable for the successful innovator. And I've found in this town, and yes, I'm from California, I've found in this town that the incentives argument usually is raised by those who want to defend conduct by an incumbent. If you interfere with what the incumbent is doing, maybe you'll be diminishing incentives to succeed to the position of incumbent, and that can be a legitimate argument. But incentives matter for others as well, and I think that's very important. So what is the core antitrust doctrine? Rob mentions, the report mentions these four. I've said, and Janet said, that some of the distinctions seem a little less stark in practice and in modern thought than the report depicts them as being. What do I think is the core antitrust doctrine? Here's my attempt to put it into words, and please, I didn't try very hard to wordsmith this, so please don't try too hard to pick it apart, but I think it captures the spirit. Okay? If you make a better offer, you'll get more business, and that process should be profitable. That's pretty much it. Okay? If you think about cartel enforcement, it captures cartel enforcement because what goes wrong there is if you make a better offer, instead of you attracting more customers and being profitable, your rivals will punish you. Merger enforcement is a little less direct, but one can say if you make a better offer, you attract customers away from other firms, including perhaps your proposed merger with your partner, and the merger eliminates the incentive to do that. If you think about a lot of monopolization concerns, those too can fit into that general framework. So a couple of things I'd like you to notice about that. One is it fits very closely with the concept of creative destruction. That is one of the things that we remember from the voluminous and sprawling writings of Joseph Schumpeter. Okay? Doesn't fit particularly well with the other thing that people remember, which is pre-established market power might be a means to raise money that then might be devoted to innovation. Okay? So there's a difference between the Schumpeter of creative destruction, who's really all about keeping monopolies very fragile and vulnerable to creative destruction, and the Schumpeter of the large industrial enterprise as the way to finance R&D. I think it's important to distinguish those Schumpeters. I have no idea how he managed it in his own mind, but they're very different from an antitrust point of view. And when people bandy his name about, I think it's important to be clear which of those Schumpeters they're talking about. The other thing I would say is that the central doctrine of antitrust is that the approach I described is held, this is where it's doctrine, to work better than believing people who say, trust me, I can centrally manage everything and it'll work well. Here and there in his remarks, I got a little concerned that Rob was perhaps falling into that credulity trap, as I see it, and I'm a hardcore devotee of that central doctrine of antitrust. Okay? So, for example, he mentioned the idea that a merger between competitors that raises price by increasing market power might lead to a reduction in cost. Now, by the way, that idea, from a modern point of view, is not all that far to see, and that's largely because Oliver Williamson, in a perhaps prescient paper, published it in the 1960s. Okay, so that idea goes way back. However, if you look at the evidence, it's not all that compelling. the finance literature has measured the profit impact, at least as estimated by the stock market, and to some extent as measured as best we can from accounting data as well, has measured the profit impact of horizontal mergers. Typically, horizontal mergers are jointly unprofitable for the participant firms. Okay? So if you have an increase in price and a decrease in cost, that's a bit of a puzzle. We also have evidence from the rent-seeking and corporate behavior literature that when prices go up, costs tend to follow them upwards. Firms that are not under competitive pressure tend to become internally inefficient. Costs go up when prices are high. So I would say it's perfectly possible, of course, that you have a merger that increases market power, that might even increase price, and that reduces costs. And Williamson's article on that is a good starting point for thinking about those issues. But I also think that by and large, that doesn't seem to be the way the world usually works. And I would also say that there's a reason to be a bit skeptical if the parties come in and say, this is how it's going to happen. The general doctrine, as I say, that ensuring incentives for better offers by a multiplicity of players is a better idea than believing someone who says, trust me, I'll manage everything centrally and it'll be efficient. That strikes me, as I say, as a reasonable formulation of what I take to be the central doctrine of antitrust. And when I look back at the Section 2 report that Janet mentioned, it contains a lot of very thoughtful discussion and a lot of valuable information and a lot of good pointers to both cases and to some extent even economics literature. But to me, its central flaw is that it was a little too willing to admit as likely the possibility that integrated centralized management of a broad swath of a market might be the efficient way to do things. It is possible. But by and large, I think it's our experience that that's not a good way to do things. And by and large, it seems to me that's the approach that antitrust ought to and does take. Thank you.
Let me thank you to all three of you. Let me just make a couple of quick responses, and then we'll open it up. First of all, I think maybe the way I would interpret what Janet and Joe said is that we won, so done. But more seriously, yeah, I certainly, if I implied, hopefully not in the paper, that somehow that current antitrust thinking, particularly in this administration, even the last administration, didn't understand these issues, have not evolved over the last 15 years to take innovation and think about innovation more deeply, then that was my mistake. Certainly, I think that innovation has been incorporated more, and to some extent it is pushing on an open door, but that's sort of our job, is to keep pushing on that door and make sure that door stays open.
Yep. Open wider.
Exactly, open wider, so I agree with that. I guess with regard to maybe Janet's point and also Joe a little bit, I certainly think there is, obviously when you're writing a report like that, you are trying to, in one sense, kind of make stark comparisons just for illustrative purposes. But I do think there's still differences. A couple of years ago, I had the pleasure of having a debate over at the Mercatus Center with a gentleman from the FTC over a case on contact lenses and antitrust. And this is a case we've gotten deeply involved in because we were all, and still are, all for this is the early Schumpeterian argument of entry. We think contact lens sales over the internet or big box retailers like Home Depot, like Walmart, Depot for you, are actually good for consumers. But my counterpart on the debate from the FTC in the last administration, he argued that there was no competitive problem here, and my assertion was there was competitive collusion between optometrists. and won't go into all the details of that. But if you go online and you look at optometry journals and you go look at the websites, it's pretty clear that there's a professional norm that's stated, do not prescribe lenses to your customers that they can buy on the internet. Because if you do that, then they'll be able to buy them on the internet, and they'll go to you, and they won't go to us, and we'll lose market share. We'll lose the profits we have on the sales of contact lenses. Now, so the key point here was that the FTC person was saying, no, this is simply impossible that there was market power because there's no evidence of supernormal profits. This was the norm that was used to evaluate whether a market was competitive or not. And my argument was that supernormal profits were not the issue here. It was profits at all. The issue was that these thousands and that was the other thing. There couldn't be market power because there were 10,000 or 100,000 optometrists in the country. This isn't like Intel and AMD. This is a distributed market with no market power, no pricing power. So how could there be a problem? And my argument was, from the innovation doctrine perspective, there can be a problem. Because what was going on was collusion through professional norms. It was clearly the case. And that collusion was solely to keep consumers from being able to go and buy their product, their contact lens, from a more competitive and more innovative distribution channel. So I get the notion that there's this more of a consensus around it, but I do think on certain areas that there's still there still are these differences. Last point on Schumpeter. I think Schumpeter, my own view is his thinking in theory of economic development, which was more the creative destruction argument, which was written in, what, 17, something like that, very early on, that his thinking changed as the economy evolved. And economy, corporate R&D labs came about, and he ended up sort of getting into this notion that, well, maybe market power is good, and maybe it's not creative destruction, but it's certainly innovation. So I don't know that there are really conflicts between those points, but I think they're complementary. I think you can get innovation through incumbents by them doing their own innovation and frankly having enough market power. I mean, I think there's that inverted U of innovation. If you have, is it the inverted U? Yeah, if you have too much market power, you don't have enough innovation. If you have too much, you don't have enough competition. So there's that sweet spot you want to be finding. And I think some people in antitrust still would view that sort of hyper-competitive markets are optimal to innovation, and I don't. It may be sometimes the case, and maybe it's not the case. So I'll stop there. I don't know if anyone wants to respond to that, or we can just open it up.
Well, let's see. I'm not familiar with the contact lens case, but it seems to me that on the theory you describe, there would be a price effect as well as an innovation effect. And so if, hard to believe, my colleague got it wrong, he or she would have been getting it wrong on price as well as on innovation.
There was no price effect, because it's just simply a case where you're buying a contact. They make their profits on a markup, and let's say the markup is a perfectly legitimate markup. So they sell a lens and they make 30% of the markup, and let's just say that's a competitive markup. The issue for them was not that they can make 40. The issue for them is they don't get to make a sale at all.
Yeah, because a lower cost provider would make it, and at least in the long run, would do so at a lower price.
Absolutely, but
so there's a price effect.
On the price effect, on the other hand, I thought you were saying a price effect in the price differences you'd see by more heavy markup than
no, it's no.
Okay.
I just price effect.
Okay.
On the inverted U, I think there's some very subtle issues in there that we probably don't have time to get into. Let me just say a little bit about fact-specific merger enforcement, though, because this is something I meant to say earlier and I skipped over it. Janet mentioned that merger review is highly fact-specific these days, and that's true before there's an enforcement action. It's not always true before an investigation is closed, because we investigate in many years thousands of mergers, and there just isn't time to do a highly fact-specific investigation of all of them. So what tends to happen is that many mergers go through on relatively quick and formulaic investigation, and the ones that don't they get the fact-specific expert investigation. So actually, mergers in some sense get the benefit of both methods of analysis.
Great, thank you. So why don't we open it up for comments or questions? If you can raise your hand and identify yourself, and if to anything in particular, please say that. Right back here.
Larry Sargent. And my
Hold on a
question.
second, sorry, we're getting the mic just so people who are watching this live, I'm sure there are thousands of people around the world now.
And anyone who wants. Anyone who wants to answer can answer. It's not directed to anyone in particular, but a lot of discussion recently, particularly with respect to American multinationals, about the need for U.S. tax policy to be more accommodative and reflective of the competitive position that those multinationals are in when you look at tax policy in other countries. And my question is there a corollary argument to be made that prevailing antitrust laws should also be more accommodative, particularly when you look at the competitive position of multinationals against other multinationals that are based in other countries, for our antitrust laws to be more accommodative? And Rob touched on this point in his opening remarks, the fact that our view of how markets should operate don't always operate, and in fact that sovereign nations actually at times do put their finger on the scale in favor of their own companies. Or is it already accommodated with that?
Antitrust has been one of our most successful exports. There are more than 100 nations in the world today that have antitrust laws, probably 120, and almost 100 of them that have merger notification requirements. We and the European Commission have been the principal exporters of the methodology for looking at things. There's an international competition network that meets annually on a plenary basis and meets regularly on smaller level basis, is an effort to try to educate emerging economies in how to enforce the antitrust laws in ways that make sense. It's obviously a sliding scale. There are incredibly sophisticated antitrust regimes in the United States, Europe, European Commission, less sophisticated in some emerging economies. So it's a problem, and there is a genuine problem in having inconsistent outcomes and inconsistent methods of analysis across the nation, across the world. But having said that, I think that the way the United States and the Europeans have approached this in an effort to try to help emerging economies understand the right way to do it is probably the only alternative. It's not as though we can bar Korea from enforcing its law against companies that choose to operate in Korea. We are all genuinely concerned about China. So far, Chinese enforcement in the merger area, most of the mergers that have had remedies imposed by the Chinese regime have involved non-Chinese companies. But all of the cartels that have been prosecuted so far in China have involved Chinese companies. So we don't really know where China is going. I think cautious watching is where the antitrust community is on China right now. There are some people in China who want to do the right thing. There are genuine concerns about by Western companies that they may be forced to license their intellectual property in ways that they would not choose to do as part of an antitrust regime in China. It hasn't happened yet, but there is real concern. So I guess the short answer is there are differences. The differences between the major Western enforcers are not as stark as some people think they are. There have been, and there have only really been two conflagrations between the United States and Europe, and one of them was GE Honeywell, and the other was Boeing McDonnell Douglas, which ended up working out in the end. And there's been a lot of convergence on how to approach these issues between the Western enforcers. I think the greater concerns are with respect to emerging economies.
No, we'll go to, let's go to Jonathan first, and then.
my name is Jonathan Zook, and I'm from the Association for Competitive Technology. And I'm proud to say I'm neither an economist nor a lawyer, but over the last 12 years, I've had occasion to spend a lot of time with both, and studied a little economics at SAIS. It seems like the role of economics and antitrust sort of happens at two places. One is the decision about whether to investigate, where I'm making some sort of analysis about demand elasticity, that, you know, if I have a great new product, is it easy for people to go adopt it? And then also in the construction of more structural-oriented remedies. In other words, if I just find that there's actually a problem in the market, and then go do an economic analysis to go figure out what might be the best way to somehow fix the problem that's occurred. But somewhere in the middle of all that is just plain old conduct. And so we say, and this is sort of where, at some level, the intersection of the legal system has to become a part of the discussion. It can't be that every time there's a discussion of an individual case, we should start having a whole new slew of economic studies about it. At some level, there's just established law and precedent as a result of having to sit through a 10-year antitrust case and Court of Appeal decisions, et cetera. Decisions were made about the role of middleware, for example, in platforms, and the effect of that on the ability of third parties to adopt platforms, for example, right? So that was the point of the Java piece of the Microsoft case, is that potentially made it easier for applications developers to develop for these other platforms, which would make them more enticing and make it easier for them to adopt it. So if I now have a firm that out there that I won't name, that has a platform, say, for advertising, right? And it's the dominant platform for advertising, and the labor then, the analog, if you will, to application software development is planning an advertising strategy, right? My analog there is figuring out where I'm going to place ads, what quantity, where I'm going to use them, for how long, et cetera. That's where the labor intensity is in that advertising market. So that labor has to be worth doing, and so in smaller advertising platforms, it may not be worth doing. So then you see the evolution of so-called middleware, if you will, that allows me to design a strategy and then apply that strategy to multiple advertising platforms, right? Well, it seems to me that the result of the Court of Appeals decision against Microsoft would suggest that preventing that sort of middleware from functioning would, at the risk of using a legal term, be just sort of per se illegal. Right? I'm a dominant player, and there's no economic efficiency, there's no benefit to consumers. The only purpose of preventing the use of that middleware is friction and blocking of demand elasticity. So why is there something in the middle where I don't need to go through all this economic analysis, and an investigation can happen in the short term, and I can just say, here's 10 things you need to stop doing because it's now the law that you can't do them. And it's no longer a question about whether or not I'm a populist or Chicago School of Economics. Is there some middle ground where antitrust enforcement doesn't need to take 12 years and the work of hundreds of economists to accomplish anything?
Maybe I can try to respond now.
Sure.
And because I think about antitrust enforcement policy questions frequently. First of all, that's the reason I made the point about how antitrust is a sort of a living document. I mean, antitrust is not the tax code, and I think something that Rob said. Rob said antitrust is not a science. I sort of say something very similar. Antitrust isn't a science; it's an art. And I don't know that you can easily. Every case is different. All facts are different. You can point to a checklist of 10 things to take care of your problem. However, I will say, as Joe just said, I mean, a lot of investigations are resolved. The vast majority of them are resolved without any action being taken within 30 days. I guess it's 80 or 90% of HSR investigations filings don't get a second request. So I don't think that maybe it's as big a problem as you seem to say it was. But I think you have to recognize that once you get beyond that, and in addition to that, I'll say, there are guidelines, there are precedent. These things are not unguided. But at the same time, it inherently is a flexible doctrine, which evolves over time. And I don't think there's anything wrong about that. I don't know if my colleagues have any different views.
No, I agree with that. The one area in which antitrust moves very quickly is hardcore analysis. The question then isn't whether it had some adverse effect. The question is, did they in fact sit in some smoke-filled room and agree to reduce output or raise prices?
So first of all, merger sets at 80-90%. It's actually 96% or thereabouts.
Thank you.
Almost all mergers get through without a second request. The statistics are published on the FTC website, although it's not always easy to find. Science or art, it's not physics. On the other hand, it's not art appreciation either. When people disagree, it's not, oh, I like this, oh, I don't. It's, no, here's why you're wrong. Here's why I'm right. Here's the evidence. So I think it's unfair to say that because it's not physics, it's not scientific. Or maybe we need a third word for stuff that is disciplined, fact-based, subject to objective disagreements, and in some cases even ex post verification of who was right and who was wrong. But it's not physics.
No, I absolutely agree. It's not our appreciation. But it's not physics. You know, you ask a physicist how to do something, every physicist is going to give you the same answer unless they're an idiot. And this is you're going to get multiple answers from very, very smart people. So, yeah. Yes, sir.
Dan Brenner. Going to something that Joe Farrell said, I believe innovation is a very important concept. It just seems like it's a pretty imprecise vector in the antitrust world, because there isn't a merger applicant who would not be advocating in this day and age the innovative benefits of the merger. At the same time, you can go into the idea of cartel. You could have cartel pricing that could be justified as a way to innovate. And you might even think about what happened. How did broadband internet get built by the cable incumbents? The government didn't shower them with money. The money came from some pricing behavior that led to excess to enough money to reinvest in their platforms. And that's a very good thing. But putting that aside, I guess the question narrowly, Rob, is if you agree that it's a kind of an unspecified vector, and merger applicants are going to use it as a public policy argument. In many mergers, conditions are put on, such as in the AOL merger or in last week's Comcast merger, in which nobody really reviews whether it is correct antitrust law. It's just that the merger applicants either agree to it or don't get their merger through in a timely way. So the risk is that the agencies will have an innovation agenda, such as the famous AOL enhanced IM condition, which was science fiction in the end and pulled back by the FCC. And so it's a little risky on both sides. In other words, the applicant will push it, the merger review team will also invoke it, and we really can't measure yet.
Well, I think that goes really to the core issue on not just the antitrust part of this, but the entire debate around economics, whether it applies to tax policy or anything else. I would argue, and a lot of people have said this point as well, that the reason innovation doesn't get a fair shake in any of these economic discussions is because it's very, very hard to measure. And you don't have the same metrics and the same quantitative variables that you do, and so a lot of econometric modeling, it doesn't incorporate innovation and dynamic effects just because it's very, very hard to do. But, you're better off being half wrong than 100% wrong. And I think that it's incumbent upon us and folks in the government and folks in the academy to become a little bit more rigorous about defining innovation and coming up with some general, maybe it's Jonathan's point, some general rules of thumb about that. But I think just because it's messy and hard, which I agree that it is totally messy and hard, doesn't mean that it's not critical to do it in a better way than we're doing it. Ignoring it, I would argue, guarantees a worse result. Then you're just throwing darts at a dartboard. Because we all know innovation is important in making these decisions. It's really hard to figure it out, but ignoring it to me just leads to a much worse decision. Now, I agree that both sides can use this, both sides in an argument, plus also the government. Everybody can use this in a way to justify things in a less rigorous set of standards than in maybe a more of a price standard. But it doesn't mean that we shouldn't be working on it, and doesn't mean that people can't challenge each other to say that's a misleading or inadequate argument you're making to make the case for innovation. And I think that's incumbent upon everybody to do that.
And part of the theory of antitrust is that having multiple firms is likely to spur innovation because a monopolist has little incentive to innovate, whereas having the correct sort of creative destruction that Schumpeter talked about is more likely to spur innovation.
Sure, but again, I guess it goes back to the messiness of it. Then there are issues around platform technologies which have different dynamics than others, sort of more widget technologies. And so, again, I think it's one of these things where we all just each have to really look hard. And I think over the years, the past 10 years, we've gotten a lot better. I mean, I agree with Joe in the sense that there's a lot of good academic work out there we now have a much better sense of how these markets work, and we have a better sense of how innovation works than we did even a decade ago, and a decade from now we'll have even better. Okay, I think we're probably out of time, so thank you for your attention and interest, and please join me in thanking